Our session is starting. Let's join the class. Let's join the Zoom.
Good evening, everyone. I trust you all can hear me. Good evening. Welcome to week 4 of our Gypsy Mentorship and Internship Program. This is the fourth week of the mentorship program, and today happens to be our practical slash mediation simulation class. So you're all welcome to today's session. We are happy to have those who are able to join in on time here. We look forward to having more mentees join in. Please, if you know you have friends that are supposed to be in session but are currently not here, please you can kindly send them notifications that our session is about to start or it's starting. It has already begun. So just to quickly make a short announcement before we get on with the rest of the session. Registration for next quarter is ongoing, right? If you want to be a part of maybe another course in our next quarter, or you want to refer our program to other mentees, please, other people, your colleagues, your family members, relative, co students, you can kindly let them know about the Gypsy Mentorship and Internship Program, and if at all you need the registration link, you can reach out to me and I'll do well to send it to you. So, once again, well, welcome to today's session. My name is Dennis Williams and I'll be your moderator for today's. Sorry, I'll be your moderator for today's class. So quickly, just to introduce our mentors, the mentors that we'll be having on call today, on session today. We have the one and only Mr. Nacham Nanwan. Mr. Nacham Nanwan, thank you, sir, for being here. Not to not to read, not to like give too much emphasis to reading of profiles, since that we've done that from the first week up to now. I would just like to read just the first few lines of his profile while we introduce our other mentors for today. So, Mr. Nacham Nawan is a lawyer and the principal partner of the law firm N. Yanchan and Co., a law firm based in Kaduna, Nigeria. He's a certified teacher, trainer, and facilitator. He is a faculty member and director of the Settlement House ADR Training Institute, an institute for training, um, certif- certification, and practice of alternative dispute resolution. Like I said, not to give have so much focus on put so much focus on the reading of the flyers, considering that we've most of our mentors have been with us right from week 1 and we have read through their flyers. So I will not be or doing so much reading today. So thank you, Mr. Niachan, for joining us. It's always nice having you in session. You have been a core part of this particular course, of this particular training that we've had. I want to say thank you for everything that you do. Thank you for always taking out time to mentor us and being here. Um, our second mentor for today is Miss Baratu Johanna Dangana. Ms. Baratu Y. Dangana is passionate about dispute resolution as well as core legal practice. Her desire to see that disputes are resolved amicably in our society propelled her to enroll and become a certified mediator and arbitrator. She is a full member of the Settlement House ADR Training Institute, an institute for training practice and certification in ADR. We want to say a big thank you to Miss Baratu for always being in class and always being in session. Just like Miss Anya Champ, she has been with us from week 1 up to this particular um, moment, and I'm sure we'll be getting to hear from our mentors after our mentees have done or given us a piece of the simulations that they have put together. So you're welcome, Ma. She's not yet here with us, but we trust that she'll be joining us shortly. Our third mentor for today It's Mr. Sorry, my screen is a bit faulty. It's Mr. Samuel Orobosa Osarenren. Mr. Samuel is a mediator and arbitrator, a peace advocate, a negotiator, and a distinguished ADR practitioner to the core. He possessed advanced knowledge and understanding in peace and conflict advocacy, in peace and conflict, in peace, in peace and conflict advocacy, community mediation, family mediation, workplace conflict management, and resolution, peace building, amongst other. He is a minister of God. He holds a PGD in theology from the of Redeemed Christian Bible College, a graduate of the Word of Faith Bible Institute in the Living Faith Church, a lover of peace and the youth. Thank you, sir. Mr. Samuel is not yet here with us, but we trust that we'll be having him shortly join us in the session. Moving on to our next mentor for today, we have Miss Eunice Olatunji. Eunice Olatunji is a seasoned legal professional with nearly 2 decades of diverse experience. She served as the lead counsel at Hepzibah LP, a full-service law firm in Lagos, Nigeria, and head of the dispute resolution unit in in Alimasu and Associates law firm for several years, where she specialized in business analysis, dispute management, negotiation, and mediation. Ms. Eunice, thank you so much for always volunteering to to mentor rather, and being with us in our sessions. We'll look forward to hearing from you in today's session. Thank you very much, Ma, for choosing to mentor. Our fourth mentor for today is Miss Natalia Odidika Eziebo. Sorry for my wrong pronunciation. Miss Natalia is an accomplished legal practitioner, accredited mediator, speaker, trainer, and author of the book Seven Steps to Handle Depression. And that many don't know. She is the founder and principal partner at Nativity Attorneys, a legal practice that specializes in mediation and advocacy services. Natalia is also the creator and the host of a weekly live program on Facebook called Legal Moments with Nat. She offers free legal guidance to participants. Thank you so much, Miss Natalia. Um, Miss Natalia is also not yet here, but I'm sure that she will be joining us shortly. And I think that's that for our mentors for today. Um, Thank you once again to our mentees for joining us. You're all welcome to today's session. We look forward to having a very interactive session today. It's our practical session, and I'm sure that in whatever we do, we should put in our best to make sure that we have a very free going and an easy going and a free flowing class. So, just to kickstart today's session, I would like to call on uh, our different parties, those who will be taking or participating in the simulation process for Group 1. Please, we just want to give you about 15 to 20 minutes to just give us a little of what you people have done in terms of the mediation process that you people are supposed to carry out as regards the case study that was sent to the group. So, Group 1, please, the floor is yours. You people can have your mediation session. I'm sure Mr. Nyacham is here. He's taking notes of everything that you people are doing after the mediation simulation from both Group 1 and Group 2. Then we'll have our mentors give feedbacks, make correction, and just give an overall insight into maybe some of the mistakes that may have been made and also give his correction. So, Please, can we have group one come step in to make their to take on their simulation? Okay, please, those in group one that are supposed to participate in the simulation, please, you can unmute yourself and then start. You can introduce yourself and the rules that you will be playing. Okay, I can see several of you. You like are already tuned in, so please, if you can just go ahead and start.
Good evening.
Yes, good evening. We can hear you. Please, the group leader can just go ahead, or the person that is supposed to coordinate this particular process can just go ahead and introduce and let us know what you will be, the procedures you will be
Okay.
carrying out.
Good evening.
Yes, good evening,
My
Joy.
name is Joy Marlo.
Your network is not too clear. Hello,
Hello.
Joy. Yes, we
We
can hear
can
you
hear
now.
you, Joy.
Hello.
Yes, we can hear you. Please go ahead. We can hear you now. Go ahead.
Okay. Good evening. And I will be the mediator for today's session.
All right, please go ahead. You can please. I would
Please,
also like
other
to ask that you put
participants
on
in this
your
particular session.
please, if people can you put on your video so that we can see you?
Okay. Other participants in the bunch, please introduce themselves. Okay. For this. Okay. Thank you. Good to serve as your mediator for today's mediation.
Your Joy, your network seems to be
Process. I
very
believe that
bad.
this will be a helpful procedure in order for your dispute. I am certified data and working in the settlement house ADR.
Joy, can you hear us? Your network is shaky. Please, hello, Joy, can you hear us?
Okay, please, can you hear me?
Yes, sir, we can hear you, sir.
Okay, so for the practical sessions, we need a group leader to introduce. We need a group leader to introduce to us the members, whether you are going to have one mediator or two mediator, and then whether you are going to have one representative as per a party. Can you hear me?
Yes,
Yes, we
So I can
can.
hear you.
Yes. So and you introduce your group members, introduce the people that will be representing the group members, and then um, we expect that those that are going to be participating, their videos should be on. So, but in case of any difficulty, if your network is unstable, you can put off your camera for a while, and if it is stable, then you can do the needful. Okay, Mr. Samuel is here with us. So please let us know who and who is doing the needful. Then the admin, Mr. Denny, or you can
Yes,
just
sir.
make me an admin. I'm going to rename the parties, or let them state their names. The mediator, you are going to add mediator to his name. The party A, the name is going to be renamed. That's the name of the person in the group. You put your name and say, Mr. Musa or Mr. So also for party A and party B, so that we will be able to know who is involved in the process. I hope that is understood.
Yes.
Yes, I very understood, sir.
Yes, sir.
All right, thank you.
So
So you
please
can
go
go
on.
ahead.
Carry on.
Can I start?
Yes, please.
Yes, carry on, carry on.
Okay. Good evening. I'm the reader for this week's meditation. My name is John Emmanuel, and I shall also serve as the mediator for the party mediation session. Party A, my group members are
Sorry. While it seems Joy's network is very bad, right? So can we have someone else do the introduction on her behalf while she rectifies her issue?
okay.
Good evening. My name is Mono
Members
Sokorinda.
of she are currently
Okay, I think Joy, you can go ahead. We can hear you now since your video is off. Go ahead.
fans are Gloria Oluchi Jude Akaronye, and she'll be serving as the representative for A and B company, the council. That is party B. Then the council for Mr. Musa for this mediation session is Augustine Chimachidi. Our parties are for Mr. Musa Manasoko Rimdan, and for A and B company, it is Hawa Yahaya Sayuti. She is going to serve as the company secretary. I am the mediator. We shall have only one mediator for this mediation process. Thank you. So hello, please, can you hear me?
Yes, we can hear you.
Yes, I can hear you. Please go ahead.
Hear you now.
Okay. As I said earlier, my name is Joy Emmanuel Inobong, and I shall be the mediator for. I am a certified mediator of Settlement House ADR Training Institute, and I will a reasonable means of resolving disputes between you two. I hope that you find mediation a helpful process in resolving your disputes. And I believe I must lay down the ground rules for this mediation process. First, everything here must be kept confidential. It shall not be disclosed outside this mediation process. Secondly, I hope that we can share our opinions and listen to each other's opinions. Thank you. So please, party A. Hello.
Yes, we can hear you, Joy. Please go ahead.
Party A is and I believe I'm going to read out the facts of this case, facts of the case that has been presented to me. Mr. Musa applied for a job with A and B company. Mr. Musa resigned from his previous job and moved to valid contract from A and B company. Before Mr. Musa could resume his new job, the government imposed a lockdown due to the COVID-19 pandemic. Mr. Musa has not been paid any salary for 8 months since the lockdown began, and he has not been able to return to his previous job. So, the legal officer, please, can you introduce yourself and please give your page? understood. Thank you. Mr. Augustine.
Good evening, everyone. Augustine Chima
Mr.
Chidi.
Augustine.
Yeah, can you hear me?
Yes.
Can you hear
Go
me?
on.
Yes, we can hear you.
Hello, can you hear
Yes,
me?
we can hear you.
Okay.
We can hear
Okay.
you.
Thank you. I'm Augustine Chima, counsel representing Mr. Musa in the course of this mediation proceeding. Mr. Musa is an employee of A and B company, and he has worked with the company for over 9 months before the pandemic. However, during the pandemic, it happened that the government imposed a curfew and the company was shut down, and members of the company could not work physically with the company. Rather, they were all sent a letter that they should be working from home, they should work remotely. However, Mr. Musa spoke with the manager and applied that they should direct him on the work he'll be doing remotely. But he did not get any letter from the company, that's A and B company. Neither did the HR. He was assured that the HR will relate to him through his email or through their WhatsApp platform the mode to which he'll be working. However, all throughout the period of the pandemic, he was not notified of how he will work remotely. And when he wrote to the company asking that for this period of time, he has not gotten any letter or any memo from the HR, the manager still assured him that the HR will relate to him. However, all throughout the period of the pandemic, he was not given any letter on how he could work, and he was still not paid his salary. And I believe as an employee, when he signed with the company, they had a contractual agreement that he'll be paid his salary at the end of the month. And all throughout the pandemic period, he was not paid any salary. And also, he had a contractual obligation with the company that during the time he's a member of the company, he cannot sign any other contract with another company. That means he cannot be working with another company while he's still under A and B company. This happened, he could not get himself another job, neither could he get any means of feeding himself and his family. And this has caused undue hardship to Mr. Musa, my client. Also, as an employee of the company, he has fulfilled his contractual obligations by working diligently even before the pandemic, and also by writing to the company demanding that they should, as promised, tell him how you'll be working from home. And the company, all throughout that period, did not reach out to him to say, this is how you should be working. And I believe the company has a moral and legal responsibility to compensate him for the work. And as an employee of the company, he's entitled to his salary every month. And this, the company has failed to discharge their own contractual obligations, particularly by providing him his allowances, which is accrued to him, and his monthly salary. The company has failed woefully to pay all this his salary, and this has caused undue hardship and has put him in a position where he's struggling to meet up with ends meet. However, in this mediation proceeding, since we are looking at reaching to a fair ground and having a peaceful resolution, Mr. Musa, my client, explained that the company should pay him his salary that they owe him. They should pay him for the period to which they have not paid him his salary, even the pandemic period, because he is still an employee of the company and he has not resigned from the company. Neither has his contract with the company been terminated. And that is why he's standing on this ground to say the company should pay him the sum of 20 million naira as a compensation and then full payment for the salary to which is owed to him. I believe through this mediation proceeding, we will come to a reasonable ground and a reasonable agreement to acknowledge the value of my client's work and also the company's legal responsibility to pay their employees their salary. Thank you.
Ms. Gloria, please, what do you have to say about this concerning your client, A and B company?
Yeah, thank you so very much, mediator, and then all the representatives here present. I am Gloria Judah Karanye, a counsel representing A and B company. Okay. Now, in addressing these complaints, in addressing these claims brought forth by Mr. Musa against A and B company regarding unpaid salaries and then damages of some sort, okay, we wish to notify the House for the records that we are here to foster a constructive dialogue, and at the same time, we are open, okay, to finding a fair and equitable resolution to this matter at hand. All right, and so in furtherance to that effect, we want to dissect this issue in this manner as follows, okay? Now, first of all, it is so pertinent to point out that A and B company is a highly reputable company, okay, so renowned and well known for its commitments to its employees' contracts of employment, okay, as outlined in their contracts. Is committed to its employees as outlined in their contracts of employment, okay? So that notwithstanding, it's also very important to consider the fact that there's this fundamental principle that says that compensation comes, okay, is provided when the work is being performed, okay? So in that case, it then means that Mr. Musa's asking for arrears of payments when he did not perform any task lacks justification of any form. All right. And then meanwhile, this lockdown, government imposed lockdown, actually classifies as a force majeure events, unforeseen circumstances that's actually beyond anyone's control. Okay. And so it was highly unprecedented. It was, okay, so challenging. And at the height of it, it imposed such hardship on companies, businesses, and then employees alike, of which A and B is not an exception. A and B suffered untold hardship. In fact, it had no much job to do at that moment. Despite that, notwithstanding, actually, A and B made some genuine efforts in having a remote arrangement, a remote work arrangement for its employees, including Mr. Musa. And yet, Mr. Musa's inability to participate in this remote work arrangement was actually cannot be attributed to any action or inaction of this A and B company. Okay, so when we talk about the first point that Mr. Musa did not work, they made mention that he worked. We should remember that all the while Mr. Musa was coming to the company, he was coming for his documentations, coming to sign his contract of employment letters and all of that. The last time he visited the company was on the 21st of March. And that same month, 28th of that same month, the lockdown was imposed. That means Mr. Musa did not do any work of any sort. And then during the lockdown, he could not also do work, despite that the messages were sent to every employee. For whatever reasons, he could not get his own and did not participate. And so he did not do any work. So if he's asking for any arrears, it lacks a justification there. Okay? So, and then we want to say that if he's saying that he suffered any loss, A and B company cannot be held liable, cannot be accountable for such losses, because the event was unprecedented. It was never caused by A and B company. The lockdown was So now, more so, Mr. Musa is asking for damages of 20 million naira because he has some losses and all of that. All these claims actually lacks concrete evidence to support it. There is no concrete evidence to this alleged harm or financial losses. All right. When we actually empathize with any form of hardship Mr. Musa must have faced, must have suffered, okay, because we actually know what it meant, what happened during this lockdown, we still maintain that it's very pertinent that these claims be substantiated with some verifiable evidence, okay, without which it remains speculative, without which it remains unsubstantiated. All right. So that is what we have for now, as it is. Thank you.
Okay, good evening, Miss Gloria. Good evening, Mr. Augustine. From what you have said, it is understood that the employment contract is valid and Mr. Musa is asking or demands a compensation of 20 million. Now, Miss Gloria, on behalf of A and B Company, would you be able to pay the 20 million to Mr. Musa?
Well, for the fact that we are here to resolve the issue amicably for peace to reign, in as much as we know he did not do any work, and then as you rightly mentioned earlier, a fundamental principle that says no work, no pay. We have these options for him. We can give him 5 million and still retain him as our employee. Okay, we'll give him 5 million and still retain him, of which he will still earn more. The company is so reputable, it's a big company, he would make it up. All right. Or we'll give him 10 million and he's off. Okay, he's off the hook. That is how the company, that is what the company has instructed me to deliver to him. Thank you. Hello?
Mr. Augustine.
Yes, I'm here. I'm here with you.
Is this okay? Hello, Mr. Augustine.
Yes, I'm here. Thank you, moderator. I believe we are all seeking for the best interest of our clients.
Okay.
I believe we are all seeking for the best interest of our clients in this proceeding, and because we want to reach to a peaceful resolution, and due to the loss and the financial hardship the company has placed on my client by not paying him his salary from 2020 up to now, and also job from applying to another company, my client reached out to me now that he cannot settle for 5 million, or neither can he settle for 10 million and get his contract with the company terminated. If the company wants to terminate his contract, as stated in the company's employees agreement that he had with them, they have to pay all their outstanding debts to which they owe him. If they cannot pay the outstanding debts, they have no right to terminate his contract, or better still say they will pay him 10 million and terminate his contract. That's offering him another offer to which we cannot accept. However, because we want to get to a peaceful resolution, we would go with 10 million and then be retained as an employee of the company and continue working with the company. Otherwise, the company should pay us the complete outstanding debt to which they owe, and then we can go and look for another job elsewhere. Thank you.
Okay. Miss Gloria, do you find this okay? Is this okay to you? Is the price agreeable?
Yeah, 10 million is agreeable. It's just returning after 10 million is what the company has not comes with yet.
Okay, we shall have a private session right now. So, Miss Gloria and Mr. Augustine, my secretary will take you to separate rooms where I shall meet you individually. Thank you.
Thank you.
Okay. Please come back. Let us come back to this same room after now. Okay, so seeing a settlement, this is settlement agreement. Mr. Musa, the plaintiff, and A and B company, defendant. Mediation settlement agreement. The parties and their counsel, having met with Joy Enobong Emmanuel, certified mediator for mediation in the above action of March 27, 2024, and having resolved all disputes between them, agree as follows. 1. The undersigned parties agree to the terms and conditions of this mediation settlement agreement in Parliament shall not be deemed an admission of any fact, issue, or liability in this case. 2. The defendants, A and B Company, shall pay the sum of 10 million naira to the plaintiff Musa as damages and arrears of salary owed him from the year 2020. Payment of the settlement sum shall be made on or before the 2nd of April and shall be by cash or cash equivalent received into the account of the plaintiff's undersigned attorney's law time of the essence hereof. 4. Simultaneously execute and deliver any document necessary to reinstate the plaintiff as the defendant's full-time employee. 5. Counsel the plaintiff shall deliver drafts of any further document to be executed in connection with this settlement to counsel for the other parties hereto within 7 days from the date thereof. The counsel and their parties agree to cooperate with each other in the drafting and execution of such additional documents as are reasonably requested or required to implement the provisions and spirit of this settlement agreement as contemplated by Section 83 of the Arbitration and Mediation Act 2023. 6. The settlement is made and performance in Kaduna State, Nigeria. 7. Each party shall bear its own attorney's fee and cost of this action. 8. Unless otherwise agreed by both parties, this agreement shall be confidential as between parties and their respective attorneys and shall not be filed with the court in the above style action except for enforcement purposes or pursuant to the court order as contemplated by Section 76 of the Arbitration and Mediation Act 2023. With regard to the interpretation and or performance of this agreement or any of its provisions, including the form of oral documents to be executed, the parties agree to further mediation in an attempt to solve same with Joy Enobong Emmanuel, the mediator who facilitated this settlement. 10. Although the mediator has provided a basic outline to this settlement agreement to the parties counsel as a courtesy to facilitate the final result, and their counsel have thoroughly reviewed such outline necessary, modified it to conform to the requirements of their agreement. All signatories to this settlement agreement hereby release the mediator from any responsibility agreement, acknowledge that they or their attorneys have been advised by the mediator in writing that this settlement should be independently reviewed by counsel before executing the agreement. 11. The parties represent and warrant that 1. They have carefully reviewed this settlement agreement. 2. They have consulted with their attorneys concerning this settlement agreement. 3. Any questions that they have pertaining to this settlement agreement have been answered and fully explained by their attorneys. 4. Their decision to execute this settlement agreement was not based on any statement or representation, either written or oral, made by any person or entity other than those statements contained in this settlement agreement. It was not based on any agreement. The entire agreement between the parties, statement of their own free will, and 7. All prior and contemporaneous and statements wherein seeking its enforcement, and the parties specifically waive the confidentiality provision of Section 76 of the Arbitration and Mediation Act 2023. 13. The parties agree that this mediation agreement is binding on all parties and is not subject to revocation by any party. Agreed this 27th day of March 2024, and the representative of A and B company, you shall sign in the indicated settlement agreement. Thank you.
Thank you very much.
Thank you.
Mr. Dennis, we are done.
Okay, thank you very much, Joel, and thank you to everyone on the group, on the group one, and to the members that were able to participate in this mediation and simulation. A job well done to all of you. We'll be hearing shortly soon from our mentors giving feedback to the simulation that people carried out. But before then, we would like to hear from group two. Group two, if people are ready, um, people can go ahead and start your own um, and start your own simulation. Can we have the mediator for group two and also the two parties involved?
Okay, so please, can you hear me?
Yes, sir, we can hear you, sir.
Okay, I think we should take the snapshot.
Yes, sir. Thank you very much, sir, for that reminder. Um, okay, please, we'd like to ask mentees to turn on their videos so that we can quickly take the picture, considering that some of us may not have lighting in our room after now. Sorry, give me 1 minute. I'm working on it. Okay, please, can we have more mentees turn on their videos if that will be possible? Okay. We are done. Thank you very much. So, if you are ready with your simulation, please go ahead and start.
Good evening, everyone. Can you all
Good
hear
evening.
me?
Good evening, Favor. We can hear you.
Okay, my name is Favor Tochimilos, and I'm going to be serving as the mediator for Group 2. Favor and Azaria. Miss Ogozi Favor, are you on the call?
Yes, I'm on the call.
Okay. Master Azaria, are you on the call?
Yes, I'm on the call.
Okay, so the three of us are going to be the ones participating in this simulation. I, Favor Tochimilos, I will serve as the mediator. Miss Favor Ogozi is going to serve as Party B, which is A and B company, and Mr. Azaria is going to serve as Party A, Mr. Musa. Can you all hear me clearly?
Yes, we can hear you.
So I welcome you all to the Gypsy Mediation House. My name is
Please,
Favor Tochimilos.
you can participants should on their camera, please, except in the exceptional circumstances.
Please, an environment where I cannot turn on my camera. I had to move to a place where there is nice network, sir.
Go
Can you
ahead.
all hear me?
We,
Thank you very much, sir.
the mediator, party A and B, ordinarily we want to see your face, except go ahead.
Everywhere is dark.
Okay, so my name is Favor Tochimilos, and I'll be serving as your mediator today. I understand that you are here to, Party A and Party B are here to address a dispute a regarding a discrepancy in salary payment and communication between a supposed employee and the company. So, and I want to thank you both for choosing mediation as a method to work towards reaching a resolution. So in this mediation, my role is to facilitate a productive conversation and help you reach a mutually agreeable solution. I am basically neutral and I will not take sides. This is an online session, and I would like to inform everyone not to record this session. No one is permitted to record this session. And I would like to take permission from the parties to take notes when necessary. Is that fine by both of you?
Yes, ma'am.
Party B, is that fine by you? Can you all hear me?
Yes, we can hear you. Also, please, you can go ahead and comply or agree to the statements that was made by the mediator. Hello, Gozi, can you hear us? Miss Ogozi Favor, are you with us?
Can you all hear me?
Please go ahead, Favor.
Okay. So moving on, I would like everyone that is observing this mediation session to note a few things. This is a confidential space, and anything discussed here will not be shared outside of this mediation session. Open communication and respectful dialogue are essential for successful mediation. By this, I mean Party A and Party B, all languages used should be respectful and decent, and in respect to public policy. And the goal here is to find a solution that works for both of you. And remember again, your participation in this mediation session is voluntary. And if you would like to back out at this point, you can please let us know. Having said all of this, Party A, please, can you state your case? Counsel for Mr. Musa, are you on this call, please?
Yes, ma'am, I can hear you.
Okay, very well. Please state your case. What brought you here to this mediation? Why? What's actually happened? Can you please tell us?
I'm here to defend my client, Mr. Musa, who happens to be a staff working in Abuja before having this offer from company A and B in Kaduna, which he has accepted by having attended the interview and commenced his work on April 1st. He accepted the offer after he resigned from his job in Abuja. He now concentrates in his work here in Kaduna as he resumes
Mr. Ephraim, are you with us?
Mr. Ephraim, I discovered that you are logged in with two devices. So what you do is you can disable the volume or the speaker for one of the device. What you do is, if you are logged in with the phone, you can just go to where you can see your speaker, the mute. When you click on it, it ons and off your speaker. So what you do, you go to the end of those icons down, and you see that three dots that shows more. And when you click on that more, you will see three items: security, meeting settings, and then disconnect audio. So you can click on disconnect audio,
Yes,
and
sir.
one of the device will be logged in, but the audio will be disabled.
Can you hear me now?
So, okay,
Hello?
we can hear you.
Hello?
We can hear you.
Okay. Sorry.
Mr. Ephraim, sorry, your network seems to be very bad. Please, can you find a place where your network will be very stable for you to have the discourse? Thank you. Okay. Sorry, while we're waiting for Mr. Ephraim to rectify his network issue, please can the second party go up and please go ahead and tell us what's their own case currently is.
Okay, good evening. I am Favor Ogozi, and I am the counsel representing A and B Online Company. So, the matter that brought us to mediation today is the issue of our employee, Mr. Musa, who claims that he has worked in our company for 8 months without receiving pay. While we are aware that Mr. Musa got an offer in our company and he was actually called to come and do his documentation on the 21st of March 2020, and he was to resume employment on the 1st of April 2020, which was agreed and was clear. The government, however, called for a lockdown, which did not permit his resumption physically. While Mr. Musa reached out to the general manager of the company about the development of the lockdown, he was clearly informed he shouldn't worry. The human resource manager will give him a call and direct him on how to work and how he can work remotely from the house. However, Mr. Musa claims that he did not receive any call for over 8 months and any salary from his former employment. Now he engaged the services of a lawyer who is suing our company, the other party in this mediation, who is suing our company for the arrears of his salary and also suing for asking our company to pay 20 million naira as damages. While we understand the unfortunate circumstance that is before Mr. Musa, we also know the principle that you can't place anything or nothing and expect it to stand. Mr. Musa has clearly stated that he did not hear from our company, but he's asking for his salary and also asking for damages. And he's claiming that he has worked for 8 months, of which we had no input or no record of him working. So we do not understand why he is coming to ask for damages for having worked and not being paid. So we cannot pay him 20 million naira as damages, having not even worked at all in our company from the first day that his offer was supposed to begin. So, in as much already America.
Sorry, Favor, we can't really hear you.
Okay, should I go all over again?
No, not really. Just from the last parts, towards the end.
Okay. Well, towards the end, I said that Mr. Musa cannot place anything. He cannot place something or nothing and expect it to stand. It's clear that he has stated that he did not receive any call from our company. So how come he's claiming to say that he has worked for 8 months and was not being paid? While we understand his frustrations, having resigned from his former employment and had gotten employment from us, we also know and in our records have clearly seen that he did not perform any duty relating to his roles in our company. So he cannot stand in his right to say that he's suing us for 20 million naira damages. So in as much as we are ready to settle this matter amicably and peacefully, we are saying that we cannot pay the sum of 20 million naira as damages to Mr. Musa. Thank you.
Okay,
Can you
thank
hear
you
me?
very much. I can hear you clearly. Thank you very, very much, Counsel for Party B. So, Counsel for Mr. Musa, are you on the call?
Yes, ma, I'm on the call, ma.
Okay, very well. You can now state your case. Thank you.
All right. Based on the assessment of Party A's defendants, I want to vividly recall to her and the company that there is a contractual agreement which my client, Mr. Musa, entered into, a valid employment contract with that company in Kaduna, which he fulfilled his obligations by resigning from his previous job and accepting the offer to work, which included a higher salary. Also, Mr. Musa was given assurance by the general manager that he will be able to work remotely during the lockdown period. So despite this assurance, he did not receive any communication or directions from the company regarding the remote work arrangement, which led to his inability to work and receive salary for over 8 months. About the unpaid salary, my clients claim that there is unpaid salaries, which is based on the fact that he did not receive any payment since inception, which the company has promised him because they gave him an offer, he accepted, and then they enter into contractual agreement, even though the company is saying that they didn't do any, what did you call it? But Musa, based on that fact, he received he didn't receive payment despite being ready and willing to work as per the company's assurance. And there is a breach of contract, which the company's argument argued that Musa, with the opportunity to work, he has agreed upon, which constitute a breach of contract. Sorry to say it. But Mr. Musa upheld his end of the contract by resigning from his previous job and accepting the offer. But the company failed to fulfill its own obligation, which is a breach of contract. So based on this, my clients face undue hardship, which is due to the company's failure to pay his salaries. This has not only affected him, but also his family, included his spouse and children. So Mr. Musa now has made it clear to the company that he needs this entitlement. That's why he, he engaged the services of a legal person, a services of a lawyer who initiated the mediation process. He is willing to negotiate and find a mutual and acceptable solution to this issue if the company is willing also, because he did his own part, he played his own role, and he has a backing of the general manager, which Musa is all over this period. He has not engaged in anything, any contract aside from this one. So while acknowledging this personal relationship between Musa, I mean, his own issue, the company has to compensate him either to pay him his 8 months salary or to terminate his work and pay him damages too. By presenting these points, I believe I effectively defend Mr. Musa's position. Thank you, ma'am. What is this?
Okay, very well. Can you all hear me?
Yes, we can. Please go ahead.
Okay. Okay, very well. So Party A, having stated your case, what do you want from at the end of this mediation process? Mr. Musa, are you on the call?
Yes, ma'am, I'm with you, ma'am.
Okay, so I said,
You
having
said?
stated your case, what do you want to achieve at the end of the day from this mediation? What do you want?
From this mediation, I want two things to happen. One or two. One of them, sorry. either the company should retain my clients and pay him his 8 months salary, or if they are not going to retain him as a staff, they should pay him 20 million naira as he claim as damages.
Okay, very well. Party B, what are you willing to part with in your bid to make this a very peaceful settlement? August Favor, are you on the call?
Okay. Because my company employed him. Can you hear me?
Yes, I can hear you
Hello?
clearly. I can hear you clearly.
Okay, so I was saying that my company, employee of the company, and having failed to give him the directive on how to work remotely, we are willing to pay him 3 million naira alongside the arrears of all his salary for 8 months, and also permit him to resume immediately. That's what we are willing to part with.
Mr. Musa, are you on the call?
Yes, ma'am.
Mr.
Yes,
Musa.
ma'am.
Okay, so is that fine by you?
3 months salary.
8 months salary.
Okay. May I have can I speak with my client first before concluding on the issue?
Yes, definitely. Definitely.
Okay. Sorry, my client insists that if you will not have 8 months, at least let him have 4 or 5 months salaries and claiming the arrears also.
Okay, Mr. Musa, can you hear me?
Yes, ma'am.
Okay, so I think Party B was saying that they are willing to give you your 8 month salary arrears and add 3 million naira to the sum and still retain you as a staff of A and B company. Party B, am I
Okay,
right?
ma'am.
Yes, you are right. Very correct.
Okay,
All right, I didn't
very
get that
well.
one very clear. Sorry.
So is that
All right.
fine by you?
Yes, it's fine by me.
Okay, very well. Once again, I want to thank you both for choosing mediation as a way to settle your dispute. So, having agreed on all of this, this proceeding has come to a close. Thank you all. Sir Dennis, we're done.
Yeah.
Okay, thank you very much, Group 2. Thank you to everyone who volunteered to be a part of the simulation. A job well done to all parties involved. Now we want to go to our mentors to hear from them. I'm sure they have taken notes from all the simulations that were done by Group 1 and Group 2, and we would like to hear from them. Miss Eunice, you're welcome. Thank you for joining us. So, Mr. Yacham, over to you. Would like to hear from you first, sir. What are your thoughts, your feedbacks on the simulation that was made by both Group 1 and 2, sir?
I have my Oga on the top in this platform. So, Mr. Samuel, are you with us?
Your Excellency, I'm with you, sir.
Thank you very much. Mrs. Eunice, I don't know at the point you joined, were you able to listen to the simulation?
Good evening. I'm so sorry. I joined very late. I think I joined at the point of, it's not quite long I joined. I joined like 5 minutes ago. So I'm afraid I may not be able to give more, except for the last one that I heard 4 or 5
Okay.
months in a joint section. Yeah.
Okay.
Yeah.
That's good. So, Mr. Samuel, you go first. Then we will now speak, and then we'll proceed from there.
Thank you so much, Mrs. Nachang, and good evening, Madam Eunice. Good evening to all participants. Please confirm that you can hear me.
We can hear you, sir.
Okay. I need to
Loud and
apologize.
clear.
I may not be able to turn on my visuals at this point. But I want to actually confirm when Mr. Nachang was referring to Oga, I know I'm not the one he was referring to, because he's my boss. So let me quickly clarify that. I want to appreciate all volunteers that actually participated in this simulation.
Mr. Samuel, before you proceed, please, mentees, I would advise you to take this session very, very serious. Take notes, and if possible, ask all the relevant and necessary questions you need to ask, because this is this is the important aspect of everything that you have been doing. So please just ensure that you ask what you need to ask, and then take note of every vital and important point that your mentors will be identifying or speaking to you about. Thank you.
Thank you for that crucial remark, Mr. Nachang, my prof. I want to actually begin by appreciating all those that volunteered to be part of this. We all do know that different strokes for different folks, no matter what we've been subjected to during the period of training. Each mediation session is unique. 1. 2, each mediator over time develop his or own style. I remember we were told at some point that there are some basic things we need to understand as far as mediation is concerned. Before a session begins, you must have had some documentation which the mediator needs to confirm that he or she has at his disposal. The agreement to mediate must be there. The confidentiality form must have been duly signed by the parties, and this helps us to begin the process formally. Mediation can be ad hoc or institutional. Institutional in the sense that there's a dispute resolution center that has been engaged with the task of resolving that dispute, or as an independent mediator, parties can reach out to you and solicit your service, enable them resolve their dispute. Having said that, when the session is to begin, I know we've heard about opening statements. The mediator makes his opening statement, set the ground rules, confirm necessary documents have been duly signed, and then the parties introduce themselves, their designation, and also make their opening statement. The parties makes their opening statement. Now, by extension, counsels may decide to make their opening statement. Mediation is party-driven. It therefore means that the mediator may want to confirm from the parties, how do you wish we address you during the course of the mediation session? Not forgetting that understanding personality types play a great role in the mediation process. You must understand and confirm how the parties want to be addressed. They may want their titles to reflect. They may just be simplistic in stating that they want you to address them by their first name. You must take that into consideration. A mediator must also allow parties know that having gone through the documents you submitted, there's a need for us to hear from you as regards your interest in this matter. And that is where you must make them understand that an amount of time will be given to the claimant to speak first, while the respondent will also get his own time to speak first. Make them understand that while each party is speaking, there's the need to allow them state their points. And if any other party is not comfortable with the submissions of the other party, please do well to note your points. It's not out of place to let parties know if you have any issue, please address me and not the other party. I'm sure we already conversant with the seating arrangement in the mediation session. Each party sits opposite each other while the mediator is at the end. Flowing from what we have seen or what we watched and what we listened to this evening, I'm not too sure if the councils have become the parties and if the parties have become the council. I think it was an adulterated litigation session that we actually witnessed this evening, if I am actually correct. The parties speak for themselves. That doesn't mean that their counsels are redundant. At some point, their counsel may make input, but parties speak for themselves. In other words, the mediator, if there's need for parties to make their submissions, you make the floor open. Claimant, please, do you mind letting us know why we are here? And don't forget, before the business of the day commences, you must confirm the personality sitting in the room. Are they representing themselves? Are they representing a company? Are they representing a group? Are they representing a community? Are they representing a family? If they are acting in a representative capacity, you must confirm if they have authority to represent whoever they claim to be representing, and if they have the authority to sign any document to that effect. I once handled a matter, and it was an organization with an individual. The organization, we will not be able to come, but we will send a representative to observe the proceeding. I was so quick to respond. We appreciate the fact that you have thought it wise to designate someone to attend the session on your behalf. But please, may I know the capacity he will be representing? Because you just clearly stated he's here to observe. And they were quick to respond. Whatever you want him to do, he will gladly do it. I had to respond back to them because we needed to be sure so that our effort for the day will not be at a loss. I had to respond to them. If you don't mind, the persons we need for today's session should not just appear on the capacity to observe. He should have authority to do the needful, speak on behalf of the organization, do any document on behalf of the organization, take instant decision, or as worst case, sign some documents. So you must be sure the capacity in which people are being represented. There must be a document to that effect, either an ID card. And if the direct party so wish to give power of attorney, we must be discreet to know the power of attorney, is it just to enable the person represent them, or to confirm that the person can sign and enter into a binding agreement on their behalf? If the parties before you don't have such authority, there's no need to go on to sign such documents. We must not shy away from the fact that parties must have made payment for the session, made payment for the process before the process begins, because payment is not made for the outcome. Payment is made for the process. So irrespective of the outcome, whether the dispute is resolved or the dispute is not resolved, payment is usually made. Some mediators take full payment before they begin. Others take part payment before they begin. If it's an ad hoc mediation, it's left for the mediation provider. If it's an institutional mediation, it is left for the service center. Having said all that, you've confirmed the capacity of the person sitting by you. You must take time to understand why they are making the opening statement. Emotional intelligence sets in. You are decoding their personality types. You are trying to see how you can understand who they are. You are listening to what they are saying. We know that hearing and listening are in different levels. You are listening to what they are saying and you are observing them, because communication is both verbal and non-verbal. You are listening to them. You are watching their side moves. Possibly the mediator may have a co-mediator that seeks to take notes and communicate to the mediator as time passes on. I want to confirm the scenario that played out from the two groups. The mediator kept speaking with the counsels of the parties, and I'm sure the last group that presented, when we got to the end, the company agreed to pay the claimant 8 months. But when the claimant was asked to confirm if he's attuned with the proposition of the respondent, his counsel came up on saying, until we have paid the full months, the mediator was quick to come in. I thought I heard you say that you were going to pay. Must please confirm. That brings to the fore that the mediator must have the ability to summarize, ability to clarify, ability to carry both parties along. But as we always say, when you begin practice, you will always have an opportunity to improve yourself. When you liaise with other mediators, you always have an opportunity to improve yourself. And I want to admonish our counsels. Mediation is so free and less technical. We appreciate your tenses, we appreciate your language, but I want to appeal to you. We can make use of basic language that everybody will understand. We are not here to dig, we are here to move forward. I appreciate the last group, they were able to settle, but settlement is not the priority. The priority here is the fact that people understand what mediation is all about. But I want to congratulate the mediator because he was able to guide them. And at the end of the day, they came to a common ground. Mediation is not about you win or you lose. Mediation is about being able to assist parties come to a point where they can see the issue from a different perspective. Don't forget, they have been unable to see it from the same perspective. That is why dispute arises. We all know that dispute is inevitable. Dispute is not that wrong, but what advantage do we have over the parties? Advantage of foresight, advantage of becoming a resource expander, moving party A from point X to point B, moving party B from point X to point C, that they can now discuss and move forward. If within few minutes, both groups were able to practice what they displayed this evening, I'm sure that all of you will become great ADR experts, because obviously with time, you will get better. I want to appreciate everyone. Thank you for your time. I'm sure if I missed out anything, Eunice is here to cap it up and complete it. Thank you so much for granting me audience. Once again, apologies that my videos are turned off. Thank you so much. Over to you, Prof. Nachong. Okay, well, let me quickly add all of this. Yeah. I hope we do know that when we are done with the entire process, writing the settlement agreement is also a very vital issue. Very vital issue. It must be clear enough, simplistic, and able to capture all the desires of the parties. It is not just enough to state that the company has agreed to pay you back all your entitlements and to give you 3 million instead of 20 million and to bring you back into the company. The question should be, how will this money be paid? When will this money be paid? Will it be paid in tranches? The company can state, we will give you 3 million naira on the 12th of April 2024, and your 8 months salary arrears will be paid in 8 tranches, will be paid in 2 tranches, will be paid in 4 tranches, and the mode of payment going to be transferred into your bank account as at what date. All these specifics must be well documented on the settlement agreement. Clearly, thank you for listening. And there will be provision for the councils to sign, the parties to sign, and the mediator to sign. And from current practice, we've come to a point whereby if the settlement agreement is a 4-page document, 3-page document, parties should be made to sign each of the pages for the purpose of authenticity. And if they do wish to convert it to become a consent judgment, can be forwarded to the High Court through an ADR judge or through the multi-door court to perfect the processes. Thank you so much for listening to me. Over to you, Prof. Nachang. And Eunice, please, the floor is yours. Thank you.
Okay, thank you very much, Mr. Samuel. It's always a pleasure. It's always a pleasure meeting and listening to you. You know, we always tap from your anointing when it comes to these things. So one of our senior friends and mentor is here, Eunice. I don't know if you want to make some comments.
Good evening, everyone, and then thank you for having me. I want to sincerely apologize for joining it late. I think I got the time mixed up. So I was in another session and I couldn't join early. But I think Samuel has done justice to all the participants, everything. And the bit that I would have loved to talk about, he has talked about it as well. So instead of just re-echoing what he said, I will just align myself with what he said. But most importantly, I want to commend everyone who has participated one way or the other, because it takes courage and it shows that we want to get better and better. And I want to let you know that the more you practice, the more you become more confident in what you do. There is no point that you say that, oh, I now know it all. We continue to grow and grow. Even your line of asking questions, your intervention, when to interject, when to talk, paraphrasing, summarizing is very, very important. And the last session, I'm only opportune to hear bit of the last session. So I was expecting that the mediator will summarize what the all have been said, all have been agreed to, but I didn't hear that. Please forgive me, maybe I missed it, but I didn't hear the summary of all the parties had agreed to, when it will take place. That we didn't hear. And I think someone had mentioned that. So I just want to encourage her so that they will not come back and say, who was the mediator that mediated the matter? So it has to be very, very clear. Don't make the terms of agreement so ambiguous that they don't even know how to enforce it. When they said it will be reinstated, to what position? Is it the same position before it was retrenched? When will it happen? How much is the money for the 8 months? And I thought I heard something funny when the client said, I will allow my lawyer to respond to that. And he said, okay, after consultation, we are proposing 4 to 5 months. What's that? Then if I were to be the other person, I would pick the 4 months. So you should know what you're asking for. When we're talking about settlement that is collaborative and then cooperative, it doesn't mean that you should give yourself out totally. And that's where the mediation advocate or advisor was coming. You prepare for the case as well. You negotiate and you know what you want, and then don't change yourself in the name of being collaborative or being cooperative. Having said that, I think I will just stop at this moment. I say thank you for the organizers and thank you for everyone who is here. Thank you, Pastor Samuel, and then Chairman Nanchand. Thank you so much for having me.
Thank you very much. I really appreciate you deeply. Well, time. Okay, so I know there is one of the mediators here who I don't know which group she belongs to. Gloria, can you hear me? Nzolantima.
Hello?
Please, can you hear me? Are you with us?
The mentee?
Yes, I can hear you, sir.
Okay.
No, it's not. I'm referring to the second Gloria. There's another Gloria. Yes, Gloria, can you hear me?
The mentee? Sir, which of
Yes.
them, sir? Please, the mentee or the mediator?
No,
Yes,
I'm not
it's two
referring
Gloria
to
they're
you.
talking to.
Yes, there's two Gloria. The
Gloria
other
Jude.
Gloria.
I
No,
can
Yes,
not
hear
Gloria
you,
you,
Jude
not
is
sir.
who that they are talking to.
yes. So, Gloria,
Okay.
you have. I'm not talking to Jude. I'm not referring to
Okay.
Jude. There's another
Okay, sir.
Gloria.
Okay, sir.
Yes. Gloria, you can hear me.
Yes, I can.
Okay. So you have watched which group do you belong to?
Group 1.
Okay. So I'm talking of I'm not referring to Gloria Jude. I'm not referring to counsel to the company, not you. There's another Gloria. The second Gloria, can you hear me?
I can hear you clearly.
Okay. Yes. So what group do you belong to?
Group 1.
Okay.
Now wait now, please.
All right. So do you have something to say concerning the two simulations?
Oh, thank you for the opportunity, sir, for asking. For me, the only thing I have to say is about lawyers when they come to mediation, they should forget about legalities and focus more on mediation because it's not a court. So they should forget about anything legal aspect, claiming anything legality since they're counsel to their client. They should focus on more mediation terms and forget about legality. That's what I can say.
Okay, thank you. So we have listened very keen and carefully to the contributions. I think before I comment, let me find out from our mentors. Mr. Samuel, are you with us?
Yes, please, my prof. I'm with you.
Okay. Eunice, can you hear me?
Yes, I can. I can hear you.
Okay. I don't know. Is it possible to take like 5 minutes to do a kind of a session, like a mediation session, just quickly for the mentees to see? Hello?
Hello. Okay.
Yes, you can serve as the mediator. I know that Mr. Samuel and I are a little bit conversant with the facts of the case, so you can serve as two.
All right.
Mr. Samuel,
Okay.
Yes, prof.
are you disposed to? Can we use like maybe 10 minutes thereabout? Just do a little something for them to see. Then before we conclude, at least we have up to
Let's
20 minutes thereabout. Okay, so
Let's roll.
Ms. Eunice, kindly serve as the mediator Well, Samuel, which part is comfortable is okay for you? Is it Mr.
You
Musa
are
or
the boss.
representative of the company?
You are the boss. Give me a role.
No, just choose at your discretion.
All right. I think I need money and I need to be paid. So let me go for the claimant.
Okay, that's Mr. Musa.
Yeah.
All
All
right.
right.
Okay. Good afternoon, everyone. And then my name is Eunice Olatunji, and I'll be a mediator for this session. As a mediator, I'm not here to judge anyone or to give you legal advice, but to drive the process and help you see how you can move this matter forward, if possible, to resolve the matter amicably. And then, well, for me to be able to place a name, I know you've written down your name, but I would like to know parties and how you would like to be addressed. Starting with my, I can say your name as Mr. Nachan. Did I pronounce your name well?
Yes, it sounds like, but you can just call me Professor Dr. Nanchang because I have 2 PhD.
Oh,
And
that's amazing. Mm.
yes, and so the professor, doctor, I wish you can say Professor Dr. Nanchang. That would be wonderful.
Okay, that's a long one. That's a long one. I appreciate your Professor Dr. Nanchang, right?
Dr. Nanchang, that's 2 doctors, 2 PhDs.
Very well, very well. Professor Dr. Nanchang. Thank you. So sometimes if I forget to maybe call the second doctor, please permit me, I may forget, but I will try as much as possible to remember Professor Dr. Nanchang, okay?
Yes, because it's not easy to get a PhD,
I understand. Thank you, Professor Dr. Nanchang. Yes, can I go on to, I can see Mr. Musa. Please permit, I apologize if I didn't pronounce your name well. How would you like to be addressed, sir?
My name is Musa JP, but for the purpose of this section, Musa will be okay by me.
Musa will be okay. That's fine. So thank you.
My purpose of coming here today is not just to make any argument about my name, but to receive justice for the injustice that have been done to me over the past months.
Thank you so much, Musa. And then I hear you. It appears the noise is coming from your background. And then for us to be able to make a good progress, I will appreciate if you can put ourselves on mute, or except when you're talking. If you're talking, then you mute yourself so that we can hear each other well. Okay. And then I don't know if this is your first time of mediating. Professor Dr. Nachang, have you been in a mediation session before?
I don't know what you refer to as mediation. I'm here to ensure that I use my skill and knowledge to bring justice and make things better for my company. So if that is what you call mediation, fine. That will be okay.
Okay, thank you. Musa, have you been in a mediation session before, or this is your first time?
I've heard of mediation, and I think mediation is to settle people that have quarrel now.
Okay, I think both of you are right.
No, I don't have a quarrel with anybody, especially how can I have a quarrel with somebody like this?
Professor Doctor, I will have to cut you in here. Professor Dr. Nachang. Okay, so I would like to start by explaining what the process of mediation is. So here for mediation, it's a process of both parties trying to communicate respectfully with each other to know what the issue is, and then to find a way to resolve it amicably. And as a mediator, I will be here to facilitate communication. I will not be judging, I will not be advising, and I will not be apportioning blame. I will be in charge of this process to ensure that both parties feel heard. And then, if possible, you resolve the dispute that has brought you here. This is different from court case, wherein you have a judge that sits as a neutral and decide for you people. You have to come to a common ground, if it's possible. And when you are here, I will plead with you to try and ensure that we address each other with civility. I know emotions may arise. I know you may not agree with other points of view, but please, as much as possible, let's talk to each other respectfully. Let's not talk over one another, because if two people are talking at the same time, we'll find it difficult to hear, right? So when one party is talking, even if you do not agree with what they're saying, please note it down. And when you have your time, try and talk. Please don't let us attack each other. Let us identify what the issue is and then address the issue, not the person of one another, okay? And I will tell you that one of the benefits of mediation is that it's faster and then it's cheaper in the long run if you are able to resolve it. Unlike the court case that you will go on and on. Like now, I've given you time and we are here at the time. And you have control, you can talk, you can express yourself, which you may not have that opportunity if you go to court. It's the lawyer that will be doing all the talking for you. But here, we deal with facts, what had happened, how it made you feel, and what you will see going forward. So this process, it's a voluntary process. So if at any point in time you feel like you don't want to continue, please kindly let me know, and then we will come to an end. Maybe I can have a breakout session with you to find out reason you don't want to continue, but I cannot force you to be here. If you don't want to be here at any point in time, please do let me know. I am not going to be taking any side with anyone. I will remain as neutral as possible. But if at any point in time you feel that I'm not neutral in your own view, please kindly call my attention to it and I will be glad to address it. And I want to implore us to not record this session. Everything we do here is confidential. In the course of that talking, I may decide to break into private room with each of you, and whatever I discuss in that private room too will remain confidential, except what you have allowed me to reveal to the other party. However, if you are able to come to an agreement, such agreement is binding on the parties. Having said that, I want to ask if you have any question about the process of this mediation.
Please, can I go ahead and start saying why I'm here?
Okay, you will all have time to talk. Musa, do you have any question about what I've explained so far?
Not really. I can't wait to begin the process and see how I can get my money.
All right. Thank you so much, everyone. So this is how we're going to run it, okay? For us to be able to manage our time well, I'll be asking each party, maybe we call it like setting agenda. What you would like us to address? What is actually the issue? What happened? What are the things that you want us to address? I would like us to put it in the chat button. Number one agenda, can we agree? Professor Dr. Nangchang, from your own point of view, what is the issue that we need to address here today?
I think the issue here is just to say that our company is fine and good and it has done nothing wrong, and so that we'll just go our way. That is the agenda I'm here to address.
Okay, so you're saying that your company is good, you have done nothing wrong, and you just want to go without any liability. Is that what you said?
I think, you listen very well. That is wonderful. That is good. Yes.
Thank you. Musa, can I hear what the agenda from the issue from your own point of view?
I'm shocked at what Doctor had just said. I have documents to prove the fact that I was gainfully employed. I have documents to attest to the fact that we had an agreement as touching the amount I'm to be paid. I had a document that told me when I'm to resume. I had complaints that I wrote to the company stating the fact that I've not been
Okay,
paid.
I will come in now. Professor Dr. Naichang.
Did you
Professor
confirm from
Dr.
this
Dr.
man whether he
Naichang.
has gone to school at all?
Professor Dr. Naichang, please don't let me use my mute button. Okay, please. When we started, we agreed that right? Am I assuming that we're going to allow each party the opportunity to talk? When you need to talk, please let the other party finish. Then you can use the icon. But if you look at your Zoom session, there's some icon there. It has a raised hand. You could raise your hand so that I can see that you have something to say, so that we don't talk over each other and we can be able to move forward quickly. Okay. So from what I heard, Samuel, even though you didn't say it's what I heard you talk about, I think what is important to you is about payments. You talk about payments. So I can see that
and compensation.
So it appears to me that you are the claimant in this circumstance, right?
Oh yes.
Okay. So Professor Dr. Naichang, in no particular order, I would like to start with Musa to let us know what has happened, where we are now.
Why won't you start with me when I have already told you that I'm ready to speak?
I know you're ready to speak.
Before now. I don't understand.
Professor Dr. Naichang, I heard you clearly. I heard you talk about the fact that you have no liability. You don't even know why your company is here. You just want to leave. And when I hear Musa is saying that he has some money he wants some payment, he wants compensation from your company. So I will encourage us all to try to listen to one another, okay? Let's listen so that when Musa has finished, because from your own point of view, you have no liability, but Musa appears to have a different perspective from yours. So I would appreciate if we just listen to one another, then you can respond to Musa there. But I want to plead with us, okay, that this is not a forum to fight or to try to be defensive. Let's try and listen to one another attentively and to respond on the issue without being casting aspersion on each other. Can we do that? And Professor Doctor, can we do that? Professor Dr. Naichang, can we do that? Okay, very well. All right, thank you, Professor Doctor. Musa, please, you have the floor. Tell us so because of our time, tell us what happened, how it made you feel, and what you would like to see differently.
Thank you. Please, how do I address you?
You can address me as Eunice, and you can address me as Ms. Olatunji, whichever is convenient for you. I'm okay.
Thank you, Ms. Olatunji. I got an offer of appointment from the company to which Dr. Musa is the HR. I got an offer of appointment stating the terms of employment, and we agreed on my remuneration on a monthly basis. When it was time for me to resume the job, there was lockdown. Now, at no point did the company communicate to me that I will not be paid. At no point did the company communicate to me that I'll be laid off and I will not be expecting any form of remuneration. I'm a married man with children and obligations to meet. I wasn't allowed to resume. And when I made my complaint known to the company, they simply told me that the HR will get back to me as touching my request. I didn't hear from the HR. I didn't get anything from the company. Months upon months, whenever I make a submission to the company, they will always tell me the HR will get back to you. And I'm surprised that the HR is still the one here with me. I expected somebody else from the company because it is obvious that he has deliberately decided to frustrate my effort at working in that company. I stand to be corrected. At no time was my employment terminated. At no time was I communicated that my services were not needed. I still have my employment letter and everything, all the tests I did, medical tests, every fitness test to prove that I'm a bona fide member of his company. All I need is for all my arrears to be paid and for me to be compensated with the tune of 20 million naira because I have suffered. If I had known, I would have not resigned from my former employment. I would have stayed there and continued my life. That is why I'm here, to get my money, nothing else, nothing more. And if they are not ready to give me that, I know other ways to go about it in getting what is rightfully mine. That is why I'm here.
Okay, if I hear you correctly, Musa, you said you got an offer of employment from Professor Dr. Nachan company, and
yes, please.
This was during the COVID time. You accepted
shortly before the COVID.
Shortly before COVID, you accepted the offer. Please. You carried out the medicals, but you were not communicated to as to when. I'm sorry. I'm sorry, I need to pick this call. Please, can you give me 1 minute, please? Sorry.
Go ahead. Yeah.
So sorry, Mr. Musa and Professor Dr. That was my son's teacher. I needed to attend to that. I'm sorry, I shouldn't have picked call, but it's very urgent. So, Professor, Mr. Musa, from what I said, I was saying that what I heard you say is that you were offered an employment shortly before COVID, and you accepted, you did your medicals, and then you resigned from your previous place of work, but they never communicated the date of resumption to you. You tried to reach out and said the HR will reach out to you, but they never did. And because of that, you're asking for the arrears of the salary they should have paid you from the time you accepted the offer, and
yes, please.
Compensation in terms of 20 million. Did I summarize your claim well? Is that what you said?
Please. Yes, and if possible, they should send somebody else to represent their company, not this man that has been frustrating my effort for the past months. I can't talk with him.
All right, I hear you well. Thank you. So I hear you saying that you have challenge or you have difficulty or you have concern with the presence of Professor Dr. Nachan here. Is that it?
He is the source of my problem.
Thank you, Mr. Musa, for your own view. Professor Dr. Nachan, can I hear it from your own perspective? How do you react to what has been said?
I know you are conversant with the saying that silence is the best answer to a fool. I know you are conversant.
I will still want to come in here, and this is to the both parties, please. As much as possible, I know there might be bad blood. I know emotions is involved. Please, as much as possible, let us choose our word carefully. No abusive word against each other, please. No matter how I know this is a place to ventilate, but when we are ventilating, kindly let us pick our words carefully. So now, Professor, you can continue.
Well, having said so, my simple point of view would be, as a Christian, there is this portion of the Bible that says, if you do not walk, you should not eat. If you do not walk, you should not eat. And it is the government policy in this country that if you do not work, you should not be paid. And so this young man here has not worked for our company, and since he has not worked, he should not be paid. And we are not as a company willing and ready to pay for anything. You can do whatsoever you want to do, take whatsoever step you want to take, but he has not worked for our company, and our company is not ready and willing to pay anything. Simple.
Okay, so I hear you say that because Musa had not resumed, therefore your company has no liability towards him. Did I summarize your point, your position well?
Perfect.
So at this point, I would like to break into private caucus. It's part of the mediation process that sometimes to facilitate communication, we may want to break into private.
Can I ask him a question? Can I ask a question?
Okay, go ahead, sir.
Okay. Now, can you see this document? This is a reply from his office, his company. When I protested why I've not been paid, this document was forwarded to me that I should get in touch with the HR, dated 4th day of October 2023. You see this other document? The second document I wrote complaining, and the company asked me that I should get in touch with the HR, dated 2nd of December 2023. This is my appointment letter, clearly stating that I've been appointed and I was supposed to resume. This other document, I wrote it on the 10th of January 2024, stating the need for me to be paid, and they simply said I should get back to the HR. Now, this is the last document that I forwarded. Look at all the attachment I did, stating all the medical tests, the fitness test, everything I did, and my appointment letter. And they still said I should get in touch with the HR. Now, if he's saying that I did not work, therefore I should not be paid, why did the company not state it ab initio, stating that I am not a member of their office, I have not gotten my termination letter, I am still a member of the office? So with all these documents, I don't know what he's saying. Let him bring a circular, let him bring a document or any correspondence written from the company to me as an individual stating that I will not be paid. That is all I'm here for. I've shown you all these documents, shown you all this evidence. He should not just sit down there and talk from both sides of his mouth, quoting Bible. This is not Bible here. We are looking at facts, documents. So that is what I need to ask him. Let him produce any documents from the company stating that I will not be paid or stating that my appointment has been terminated. Why will the company, a reputable company, always referring me to him? I should meet him. He's an old friend of mine, so I don't know why he's doing this to me. That is all I'm here for. I need to be paid. I have not been communicated otherwise. These are my evidence. Thank you.
All right, I hear you so well, Musa. I will still want to break into private room with you first, and then with Professor Dr. Nachan, so that I can properly look at your documents, then we can talk there. Then I'll come back to Professor Dr. Nachan. Fortunately,
why are we going to a private room? We should do it open. Why private? So that he will know. Why private?
The process of mediation, it's not about proving right or wrong. We are here to solve a problem, right? You are here because you felt that you've been wronged. They are owing you and you want payment, right? Is that why you're here?
That is why I'm here, and I've showed he should prove he should show his documents. That is
so now, if I may be allowed to talk, simply ask him, has he ever worked for our company even for one day? That rests my case. Ask him.
I hear, I will still want to break into private room because I can hear from both parties. Musa is saying that the company gave him appointment letter. He had done all the medicals and he was supposed to resume, and he was not communicated to when he should resume. Meanwhile, because of the assurance he had gotten, he had resigned from his former work. or former place of work. So therefore, from the period he accepted the offer, he is asking for arrears. That is his point of view. And your own point of view is that because he had not started work, you cannot pay him and you are not obliged to him. He is saying that, well, if you are saying that you are not owing me, did you terminate my appointment? Because you did not withdraw your offer and you did not terminate my appointment, therefore you are lying. So these are two different points of view, which I think both of you, your point of view is valid in its own sense. And that is why I want to break into private room so that I can speak with you privately and see how we can move this process forward. Unfortunately, because of the time we have, we may even have to adjourn this session so that we can be more settled. I think we had just 10 minutes from the onset, so that maybe we can agree on a further date that we'll be able to come back together and then see how we move this process forward.
I'm glad you can see from my point of view. God will bless you. I'm happy that somebody is reasoning. I like the way you are just analyzing this thing. Let him know that I have a valid point, and if he's not willing to give me what I want, I will take it up. We'll go to court.
I have to go.
Thank you.
Thank you.
Okay, so please, I think you can do the caucus just shortly so that mentees, those that are able to stay, now let them see, even if it is few, just let's assume we are broken into the session. So
unfortunately, my daughter is supposed to, she has come to meet me. I'm supposed to take her to class. And
okay.
Yes,
all right. So this mediator has embargo.
you told me just to start. I was reluctant when you said it. I was looking at the time, but when you said 10 minutes, I said, okay, let me quickly squeeze in 10 minutes. So, I'm so sorry.
Thank you. Thank you very much. So this is that's an interesting session. Thank you. That's wonderful. A wonderful one. Thank you. Sorry for the headache.
Thank you.
Okay. So for the mentees that are here, I saw that people were dropping one after the other, maybe due to issue of light or something. So, but you can watch this proceedings afterward, and then you are able to pick one or two things. So maybe by way of conclude. Okay, so yes. So having seen a mediation session, I wish we had the time to actually do it to a conclusion. You see the vital and important aspect of a mediation session. Remember that a mediation is not a courtroom. I want to commend the parties and their counsels and group 1 and 2 for the job well done. They have researched, they have practiced. I was carried away by the arguments and the presentation of the counsels. I just wish that it was the parties that were saying all of these things by themselves instead of their counsel. So just as Mr. Samuel has pointed out, mediation is party driven. So first of all, counsels are there, but their role is to assist the parties, communicate, and if possible, arrive at an amicable settlement. That's the role of that's a typical mediation session. And so the mediator is there as a third party neutral that will facilitate conversation. You need to be very careful because in the last session that we did, that's the mediation session that we just conducted, the practical, there are issues that were coming up which you will never expect in a mediation session. Issues like lack of respect, insult, emotions, and all of those things. As a mediator, you should be able to be careful enough to be able to calm the nerves and all of those things, and know when to break out to a caucus. Just like you see this Eunice was about to break us into a session. From the tune of the meeting, there is a deadlock. They said Professor Doctor was not willing to say anything. And then when you see a situation like that, maybe for some of you may have opportunity to do the mediation certification training, you get to know that every tree, when you see a fruit on the tree, there is a root down. It is that root that actually gives it whatsoever it needs, and then you see the fruit down there. You cannot see a smoke without a fire, so if you want parties to resolve, you must go and identify what is that fire that is bringing out that smoke. If you decide to clear the smoke, the fire is still there, that smoke will still be there. So you must know when to go into a caucus session. So for group 1, I saw that you have a mediator, and then you have parties, and both parties were represented by councils. You cannot just send representatives, councils, to go and represent someone in a mediation session, because there are important decisions that needs to be taken, and councils will have limitation. There are certain things they cannot decide on behalf of their clients. But in a case whereby a party is coming in a representative capacity, you must first of all, as a mediator, confirm, do you have the authority to decide on behalf of the client? This is one thing that you must confirm, right? So having said so, I will want to give the parties, I want to give the mentees opportunity to say one or two things about the session they observe, and maybe they can identify on their own one or two things that they feel they have done correctly or not. Do you have someone who wants to speak?
All right. Do we have anybody that wants to contribute on the session that was made? Please, you can go ahead and listen, or we can just take from the parties that are currently present. I think Mr. Augustine is still with us. So, Mr. Augustine, can you give us a little feedback on the performance of your group?
Not the performance of the group per se. On the session we had, the mentors, they have done their session. Maybe if there is something you will be able to identify from the section, that's the practical that the mentors have. If you are able to identify anything. Mr. Dennis, please help me take note of those who are present.
All right, sir. I'll do just that, sir.
Yes. Okay. There is nobody.
Do we have anybody?
Yes, I am. Can I speak, please?
Yes, please, Gloria, you can go ahead.
Yes, sir, please. I noticed there was so much dragging. I know when we are practicing, we are meant to understand that we thought that, since it's a collaborative stuff whereby you are coming to peacefully resolve. In fact, I was actually confused about it. Is it that you now come and give in, allow everything, even if ordinarily you would have said no to certain things, just because you want peace to reign, you would just say yes, and then whatever the other party says, pay me this, you agree, without any restriction, without any, sort of saying. So, but this one, I saw the company head really, standing his feet, trying to insist that he's not going to make any payment, or that the other man did not work. And the other man was just busy, so trying to prove with all the necessary documents that he's meant to be paid and all that. So that's something I I really do not understand. Is it the mediation aspect? I don't know. Sorry, sir. I don't know. I don't understand. Mm.
Mr. Yachan, please, did you hear her question, sir?
Yes, I heard what she said. Any other reaction? Mr. Victor, Miss Victoria, please, Nita. I wanted to say Nikita because I've watched the film. Nita, please.
Okay, I think I can see Augustine's hand up. So, Augustine, please go ahead. You can make your contribution.
Good evening. Can you hear me? Can you hear
Yes,
me?
we can hear you. We can hear you.
Yes, we can hear
Okay.
you.
I I
Who is speaking?
Mr. Augustine, we can't really hear you anymore.
something in the course of the mediation proceeding. I think is Mr. Can you hear me now?
Yes, we can hear you now.
Please go ahead.
Okay, I was saying that Mr. Nathan said something. I think he was like he's not comfortable with this order if they want to change their lawyer pressing him since the whole process started for over a month now. So I wanted to ask like a kind of question. During mediation proceeding, can the other party opt out for maybe a change of maybe the counsel of the other party, or I don't know, the mediator, if he's not comfortable with the way the person is addressing him? Because he was like, this person has been stressing me for over a month now since we started this issue. So I didn't get it clear on that angle. Do you hear me, Mr. Dennis?
Yes, we heard you. Mr. Yacham, please, are you with us, sir?
Noted. Yes, please. Noted. Noted. So, yes, any other reaction? Ephraim, Nita, can you hear us? Okay, so these other persons, I don't know whether they are with us. Okay, so I think, yes, Nita, I was asking of your reaction or your input or what you have to say in respect of what the mentees have done, vis-a-vis what you have done. Mr.
Okay, sir. Good
Ephraim,
evening, sir.
yeah, good evening.
Okay, like from what I observed was the fact that only the parties were talking, and I also observed that, how will I put it? This is the question I actually wanted to ask. For the matter to be adjourned to a later date, like, is it something that's supposed to happen like that, or just something that, how will I put it this way now? Like, is it something that ought to happen always, or just something that happens if the mediator cannot actually give a make the parties to actually reach how do I put it, a settlement? That's my question, sir.
Okay, thank you. Ephraim, are you with us? Victoria. Okay. So maybe what we'll do next time, everybody will have to put on his camera so that we can be seen you put it on and off so that you won't just join the meeting and just drop your phone somewhere or your system somewhere and then you are somewhere else. I thought that this is something that some persons will ensure that they grab whatsoever they want to. So having seen Victoria, yes, we wanted to hear you. We want to hear you.
Okay, I'm with you, sir.
Did you watch the sessions by the mentors?
Yes,
The
I did.
practical. Yeah.
Yes,
So
I did.
what's your input or what's your reaction vis-a-vis what the two parties, group 1 and 2 has done?
Okay, let me compare what group 1 and group 2 did with the ones the mentors did. Real emotions were displayed in the ones the mentors did. And it was okay, it showed that it's not only should I say literates that participate in the mediation session. Also people that are uneducated with different temperaments will also participate in the mediation session. That's basically my observation. And I don't have a question for now.
Okay, I see a hand. Who is raising his hand? Augustine. Yes.
Okay, sorry, sir. I wanted to ask a question. In a situation where one of the parties to the dispute is an illiterate, and he cannot speak, and then maybe he or she did not come with a counsel, how will the mediator handle such situation?
Okay. Yeah, again, Gloria.
Okay, sir.
You get my question, sir?
Hello?
Yes, we got your question. We got your question. Go ahead.
Okay, sir. My question is because I don't know if there will be another section, another time for questioning. So I said, let me ask this now. This mediation, is it only when there is an agreement that there will be a mediation, maybe at the outset of the relationship, maybe working relationship or anything? Maybe you have maybe a family member, a neighbor, anything, somebody just trespassing, just like in the law courts, anybody can always get up one day and go and sue you for one thing or the other. Can you call for a mediation even when there was no such agreement before between you and the party? Someone just stepped on you and you felt you cannot take it, you now go for mediation, anything like that? Is it only for on commercial purposes, employment, or all this work related environment stuff? Thank you, please.
I think
hello, sir, please.
Yes. That's all right?
Okay. Yes, did you hear me, sir? Did you hear me?
Yes, very well.
Sir. Yes, that's all for now,
good.
sir.
So I will allow Mr. Musa, Samuel, to react. Eunice is there. So just briefly, then we'll conclude. Time.
Thank you, Prof. Dr. Musa. Question number 1. You compared scenario with your scenario. Yours was very calm, straight to the point, and you were wondering, why is there so much drama? Remember we said that every mediation session is unique. You are going to come across people with different temperaments. The parties may be so easy and your session will go smoothly. You may come across parties that are very dramatic. Parties that are very stubborn, parties that are insulting each other. You must have the emotional intelligence to know how you can downplay them and control your session. It is party driven, yes, but mediators should be able to control the session. If you can't control the session, you cannot move them from point A, which is the point of conflict, to point B, which is the point of dispute resolution. So emotions were high, yes. Parties were real. And you saw the way Eunice had to navigate her way through to get the confidence of each party, to make each party know that I'm on your side, I'm also on your side. That is a way of moving forward. You may meet intelligent persons, you may meet educated persons, you may meet illiterates. You must be able to balance the power play between both parties in order to move them along. If you do not get their confidence, there's no way they will believe in the process. A session can be smooth, a session can be rough. That is why mediators have the skill to carry parties along. Can a party request for a different representative? At a point, I said I'm not comfortable with Dr. Musa. If he's the one the company has mandated to represent them, and there's a letter to that effect, and he has capacity to sign, now I have no choice. He must go through the process. Don't forget, parties come to mediation in order to convince the mediator why the matter should go their way. But the truth of the matter is, parties are supposed to see how they can lobby the other party, why they should see reasons with them. So what the mediator does is enable these parties see what the other party is saying, enable the other party see what the other party is saying. Because if parties do not agree, there's nothing the mediator can do. So party A wants to explain to the mediator. A wise mediator will inspire party A to see how they can convince the other party. So when you begin in a very aggressive mode, you are making it difficult for the other party to see your own point of reasoning. So the earlier the better you tag along to see how you can convince the other party. Is adjournment necessary? You saw how Eunice skillfully brought the temper under control. And where there's a deadlock, there may be need to either caucus or adjourn the session. When temper begins to rise, if you cannot caucus, you may need to adjourn. Adjournment is better than crisis. As a mediator, you are meant to assist parties resolve disputes, not to inspire parties to complicate the issue. So when it is obvious that parties are exhausted, no more new ideas are coming into your mind, and the session is getting out of hand, what you can do at that point is to either caucus or adjourn. When you adjourn, don't forget you have senior ADR practitioners, you have mentors that are above you. You may adjourn to the following week and see how you can reach out to any of your superiors to draw inspirations from them. Or between when you adjourn and the next date, you can reach out to one of the parties in mediation. It is allowed for mediators to reach parties privately. You can call and inquire from them more about their reaction, because there may be some issues behind their expressions. Between when you meet and your next date, a lot of issues must have changed. It is possible. So adjournment is a way of navigating through stalemate. Caucusing is a way of managing deadlock. When one party is an illiterate and the other party is educated, how do you do? You must create a power balance. Nothing stops you from speaking pidgin English. Nothing stops you from seeking someone that can assist to interpret to the other party. Don't forget, in most cases, you may have been able to get the profile of the parties before the session. In some cases, you may have interacted with the parties before the session. If it is ad hoc, that means they contracted you personally in your communication, fixing dates, fixing time, fixing venue for the session. You must have been able to have an idea of their educational level, of their disposition. What if one party is a military woman and the other party is a civilian? And the military man comes into the session with his military uniform, while the other party comes in with his ordinary native. There's already an imbalance. The mediator is someone that is skilled enough to put both parties at the same level by according each of them respect and not despising any of them. Not that when one is talking, you are smiling, and when the other person is talking, you are frowning. If you smile to party A, you must smile to party B. And that is where your ground rules is very crucial. When you have a very sound ground rules and you make parties to commit to making their opening statement, it is been said the way you make your bed, so you lie on it. So when you begin properly, you should be able to handle most of these issues. Is it only when there's an agreement to mediate that mediation will occur? For arbitration, both parties must have had an initial agreement that if there's a dispute, they will resolve it through arbitration. But for mediation, there are many ways mediation can kickstart. Any dispute at all, you have issues with your landlord, you have issues with your wife, with any member of your family, inheritance, land, contractual disagreement, whatever the issue is, you can go to a multi-door court house or you can seek a mediator in registering your interest to commence mediation as regarding a dispute. Whoever you meet will now contact the other party. There's cases whereby parties go to court to file a matter, depend on the civil procedural rules of the state. At the point of filing, parties are filed in court. They are waiting for the court to give them dates. That matter can be referred to the multi-door court, and they will get notices from the multi-door court that the matter has been referred for mediation. Or a matter that is already ongoing in court, the High Court judge can refer the matter from the court to the multi-door court for the purpose of mediation. Either way. So one party can initiate the idea, initiate the process, and the other party will be invited. Is mediation only for commercial disputes? No. You've been told there are some mediators that are specialized in family disputes. There are mediators that are specialized in banking disputes. There are mediators that are specialized in communal disputes. There are mediators that are specialized in different types of disputes. So mediation is not only for commercial dispute. I hope I've been able to give insight into all the questions that have been asked. Thank you. Thank you.
Thank you so much.
Thank you very much. Thank you so much, sir.
Thank you very much, Mr. Samuel. Ogochukwu, sorry, please, you have something to say.
Ugochukwu, your hand is up. Okay, so before that, Ugochukwu speaks. So now, group one, the group one are represented by councils. So we have noted that Joy, she has done a good job. But in her opening statement, she did not give a good opening statement. And so it's difficult for the parties to get to know what the session is. Like you see, Miss Eunice was asking whether any of the parties have been in a mediation session before. So whether the parties have been or not, just give them a brief overview of what the mediation session is, so that they will have an idea. It will not be as if, okay, so this is the judge that is going to judge our case. So give them an idea about what the mediation session is in your opening statement. Explain to them, thank the parties for choosing mediation. because it's a voluntary session, parties may not be obliged or forced to attend. So for the fact that they attend and they are even there, that's something you should appreciate them for. Then set the ground rules. And let your setting of ground rules be collaborative, because a mediator is not someone, is not a judge, is not a court of law where there is this contempt of court. Once you do something, they will cite you for contempt and maybe send you to prison or something. No, a mediation session is a free session. So when you are setting your rules, you can ask the parties, will it be okay if parties talk one at a time, so that you will be able to listen to this party and this party will be able to listen to you. And in case you have any question, or you do not agree with what party A is saying, or you feel that the person is lying or whatsoever, you can just take note, and then you have your own time to react to whatsoever the person is saying. Do you think that would be okay? They say, oh yes, that is okay. So you collaboratively have established these rules. It will not be you now saying, oh yeah, like one of the mediators, he said, in setting the rules, you told them what they should do and not to do. Simple. Yes, you should take authority, but it should be collaborative. Because if you give the parties an impression that you are talking to them disrespectfully, you are talking to them, please, Mr. Musa, you can leave. It seems you are still in the office. Thank you.
Thank you so much, sir. Thank you.
Thank you.
No, I'm in my private office at home.
Okay, that's good. I can see you are still on your uniform. Please, you can see the mentors are making effort to ensure that you give what is needed, even at this time. So I wish that the mentees will be so devoted to be able to gain what they need to gain. If you are to partake in a paid session, you are going to spend a lot of money. But this is what these generous mentors have availed you the opportunity of knowing. You ask the relevant questions and then you are attended to. So thank you very much, Mr. Samuel, for your time. And we look forward to next week, which is supposed to be a practical in arbitration. And so thank you very much. You are free to leave. I'm just about to round up so that everybody will go. Our time is fast spent. Yes, thank you, sir. Thank you. So as I was saying, collaboratively agree on the ground rules, and then when you finish, you say, is there any other thing that they want to add to what you have agreed that will make the session a successful one? Once you're able to do that, please, can you confirm if you can hear me?
Yes, I can hear you loud and clear, sir.
All right, thank you. So I see that Gloria was saying, I was saying, please take them to my office. Say my secretary should take them to my office and all of those kind of things. Say, you have to be very respectful. It's a session that any other person is not allowed unless the parties that are in the parties themselves. No any other person is allowed in the room except the people that the parties agree that they should be. So it's a confidential process. You don't allow anybody. You say take them to the other room and then now come back. All of those things, you have to be very respectful in the way you speak. That's for mediator Gloria. You should ensure that you ask of how do you want to be addressed, because when you address someone wrongly, it may end up destroying the whole session. So you must take note of that. How do you want to be addressed? My name is so. In your I'm trained. I've been doing this for a while. You can call me Mr. So. How may I address you and all of those things? In your opening statement, you are giving them a background, you are giving them a foundation, you are giving them a knowledge of what they are there to do and your role. in helping them. They are the one that will take the decision. They are the one that will do the discussion. You are there to assist them. Let them all know these things. Now, after a party finishes speaking, ensure that you summarize. Summarize in the sense that let the party get to know that, yes, you actually understood, like you are following, you are listening, and you understood what a party is saying. So like you see the lawyer, when it is in group 2, when one was presenting and then they made a proposal that they are going to pay 8 months salaries, and then they will pay 3 million as damages, and then the lawyer on the other side was saying yes, that is let him consult his client. His client has accepted to pay 4 months and all of those things, and then the mediator had to come in. You can see that kind of situation. Imagine if it is the mediator and then he did not listen, and then he went to, let's say it is a caucus session, and this thing happened in a caucus session, and say, okay, you can tell them. You now went to pass a wrong information. Instead of 8 months, you are now saying 4 months. You see the damage you are going to cause in the process. So you have to be attentive as a mediator, and then the representatives. Remember, if someone is not the party himself, is coming in a representative capacity, you must ensure that the person has letter of authority or power of attorney or whatsoever that will show the level of commitment that you can commit the party is representing. So that you not finish discussing everything, then it is time for decision. You say, I have to call you, like Gloria in group 1 will say that this is what the company asked me to offer you. No, you are going there as an authority. So if as a mediator you confirm, do you have authority? Yes. So it means that anything outside of that you cannot. And you must learn negotiation strategies. So for some of you, I will beg you that you should make effort to get trained and certified. It will give you a lot of, you have done wonderfully well. You can consolidate by knowledge by acquiring more professional abilities, negotiation skills. If you go to the negotiation table and you are saying you are going to accept, you are paying 8 months salary and you are paying 3 million, if I'm the one you think I'm going to accept, I will ask for more. Yeah, so but you start somewhere. Don't give someone an impression that, okay, well, we are open, we are this and that. No, it's a negotiation ground. You have to help the other person get convinced. In negotiation, you don't just agree to something. Even when you are agreeing to something, get something in exchange. That is it. You get something in exchange. Let it be that this thing I'm giving you is something that is painful, something that is important, is something I'm losing. That's the impression you give the other party, so that both of you will be on the same footing. You get to know that, oh, I'm losing something. It's not as if I lost or the other person win, because mediation is a win-win situation. That is the thing. So you must always help the other person know that I'm letting go something and I need to get something in return, because that thing I'm letting go is a loss on my side. I don't give the impression that you have all the money you can just give. Then you may make the things difficult for yourself. Now, at the end of it, I saw that this person, the mediator Gloria, was reading a very long terms of settlement for us. You don't need your terms of settlement to be long. Just capture the main important point. They are going to pay so thing. Yes, your lawyers can be involved there. Pay 2 million naira or 3 million in 2 installments. You start your payment so time and so time. As simple as that. You can do that. You don't need to be blowing too many and plenty grammars. And you did not let us know how you even got to that agreement, how you drafted it. You started reading it for us. So we need to know, how did you get to that point? It's very, very important. Then group 2, they have done wonderfully well. Favor, she was able to introduce herself in her opening statement, and she established the place of neutrality, and then and the ground rules. Don't record anything. It is an online session and all of those things. She was able to do it. And then the issue of respect, she raised them. And this is very wonderful, and this is good. It was wonderful. Is good. So having said that, then Musa and Ngozi, they are the representatives and council. They were all represented by councils instead of the parties. So this is the parties that should always be. The lawyers are there to help in case there are legal issues, like you can see the issue of contract, the issue of agreement that came up during the session. That is the important in the lawyer's role. Okay, the implication of this and this and that, that's where a lawyer comes in. So the mediator should be able to help the lawyer see that, okay, together we can. So let us hear from your client what you want. So please pay attention so that maybe vital and important points where he missed out, you can supply, and all of those things. Not for the lawyer to go and talk on behalf of the client. Then you have taken the session out of mediation. It's now more or less a court session where a lawyer speaks on behalf of his client. But we have experts, they are called mediation advocates, who represent clients in mediation table because of their training. They have the training to be able to assist in that process. So it's very, very important. Now, having said so, one of them say he's here to defend his client. So you must understand, it's not a court session. You are not there to defend anybody. It's a place where everybody is on a good ground. You must create an atmosphere for the parties to feel free to discuss. That's why you are raising the issue of confidentiality. Anything you discuss, both in joint session and in caucus, remain confidential unless you want us to let the other person know. And then as I'm going to discuss with this person, please be brainstorming, be thinking, be brainstorming what and what you think we can do, how we can move forward from here, so that, these are things that you should be do. So the atmosphere must be good enough for conversation. Let parties be at peace, let them feel comfortable, and let them know that anything you discuss here, perhaps you are not able to settle, nobody will carry it to say, he has agreed during mediation session. Every discussion is without prejudice. Nobody will hold you to it. Nobody, not the mediator, not the parties. No, it is only when you have agreed and settled and you draft your terms of settlement that you can know that, yes, you have already crossed that border, that line, and then the agreement itself, the terms of settlement, just like every other agreement, is binding, and you can take a step further by making it a consent judgment. So these are things that you must take note of. They are very, very important. Group 2, they finish and agree, but did not draft any terms of settlement. They do not do anything about it. They just say they have agreed. Do you know that you can take a procedure? Okay, we have agreed to pay you, but in the next 10 years, if you come, say, we'll pay you now, we'll pay you, don't worry, don't worry. You see, you have to now go and start doing another mediation session to settle, or you go to court. So when you are concluded, cross your T's, dot your I's, and ensure that you are paying us 2 million. When? How? Those things should be answered so that you will not go and start another session after another session. That is very, very important. Please take note. I've raised the issue of caucusing. You take note. Now, after parties have finished speaking their this thing from both sides, you can form an agenda. The agenda will help you to discuss. Like the agenda that was formed during the mentor session was, what is the issue? This one say, I want payment, I want compensation. So you see, that is what parties are willing to discuss. So that can be discussed, So you just go to the point straight, one after the other, just like agenda for meeting. These are the things we want to discuss. There could be any other business, when you go to caucus. Your caucus session is important because, like in our session for the mentors, where there is a deadlock, what happens? You go to the distance. When you go to the caucus session, that's where you get to know some truths that parties may not be free and willing to share in the joint session. So maybe when they come to professor, doctor, he will tell you that, is it not that man that frustrated my father? I didn't know that he was the one. He was so disrespectful to my father. So I want to deal with him. I say, Ato, you have gotten to know. Or somebody is claiming 20 million. I say, please, can you help me explain how you are entitled? Those things can be done in caucus, not in a joint session, because somebody will begin to feel that, you are even partial. You are already showing sight. Doctor, doctor has started raising issues. Say, why would you want to go and discuss with the other person first? Why not me? These are issues that come up. So you need to explain. The party who brought the matter first, give him opportunity to speak. Say, sir, anybody can speak, but because this person is the one who filed or bring up the matter first, let us hear the reason why he came here with us. He came to file this matter first. Then you can now react and say your own side. That is party's opening statement. So these are things that you must take note. Now, documentation, very, very important. When you finish laboring and finish talking, one party comes and says, see, I don't even know why I'm in this place. Now you have adjourned. Our session for the mentors, they adjourn the matter for further continuation. If you do not document some of the things you have done, okay, I will be taking notes. Those notes is just for us to be guided as to some of the discussions you have had and the point you have reached. When you are joining, ensure that you have an agreement as to where you have stopped, so that when you come back, you continue from there. So, and when you conclude everything, in a mediation session, you need to understand that there are documents that you must take note of, so that somebody cannot at the end of it begin to deny his participation or is not aware of this and that. As much as possible, try to conclude your session. Where it is expedient to take a date, you can take an adjournment, but ensure that you have gotten your agreement and you noted some of the things you agree, and everybody is on that page with you. Take it, note it down. If possible, sign it. Then you can come and continue from where you stop. That's very, very important. At the commencement of the mediation, you sign a confidentiality agreement to the effect that everything you discuss here will remain here, and then you sign the agreement to mediate. That will include the terms and conditions, when you are going to disclose, what you disclose, what you not disclose, when you agree, that you take it to court for making it consent judgment, or how you want to, what is the mediator's fees, whether it has been paid. Agreement to mediate will take care of that. Very, very important. That is very, very important. And if confidentiality form and the agreement to mediate is signed, good. Then at the end of it, terms of settlement or settlement agreement comes at the end of it, when parties have agreed and settled. And when parties have agreed and settled, you take note of vital, important points. If they have lawyers, you say, okay, this is what we have agreed. Go and put it in a legal way, to protect your client's interest. And the lawyers on the both sides can put their head. But where there are no lawyers, the mediator himself should be able to assist the parties, draft this in as simple as possible to capture the main essence of what they have agreed upon. So that is very, very important. We have spent a lot of time. I think with this, I think we can stop here. Miss Eunice, I don't know whether you are in a position to say something. If not, I think we are done, except if there is any comment or clarification.
Yeah, I think you Samuel have done justice to all the questions we have. I just want to add again that one of the things that we can do as mediator is reframing. Reframing. When a party has used a very strong language, and in the process, you can try to tone it down in the process of summarizing, so that you will kind of make the environment not so tense like the party wanted it to be. You look at the example that we had. He was saying the very difficult person, and when I said I see you have concerns with the presence of Professor Doctor, I did not use that same problematic word he used, just to ensure that I heard what you said, but not in the same language, so that party still feel heard, and the other party you didn't echo the same harsh word that have been said. That's just what I wanted to add to all that have been said. I hope I was audible.
Yes, yes. Thank you very much, Miss Eunice. We really appreciate you. Thank you. So, Dennis, I will want to seriously appreciate the mentees, those that have stayed to this point. We are very I'm very happy and delighted. Please, Dennis, take note of those who are around. Then we know what to do for them. So please, I really appreciate you staying. We are here to give you value, to add value to whatsoever you are here for. It's a free session. You have not paid, but we are willing and committed to ensure you get what you get. If you do a paid session or a certification training, you will get much more. So please, thank you very much for creating the time to stay to this point. We are grateful. We are grateful. So kindly feel free to reach out to us any day, anytime. Mr. Dennis, please. Mr. Dennis. Is Mr. Dennis with us? Mr. Dennis. Okay.
Can you hear me, sir?
Yes, sir, please. Yes, sir.
Thank you, my prof.
Okay, I want to say thank you to our mentors that were able to help us run through today's session. It has been an amazing 2 hours. Thank you for the simulation process that you helped us run through. I also want to say a big thank you to the mentees that were able to step in to make their simulation a job well done. I'm sure that those who were able to stay to the end learned a thing or two from all the contributions and every perspective that that our mentors were able to give. So we've come to the end of today's session. We look forward to having all our mentees in the next session, right? And we encourage everyone to stay to the end of the session. Like Mr. Nyashan said so much in the last 30 minutes, right? So please, we would like to ask that our mentees, as much as possible, stay to the end of sessions because there's so much to learn, so much to hear, right? So we'll also try to, I will also try in my own capacity to make sure I reach out to the group to ensure that we have more mentees who are committed and willing to stay to the end of sessions. So with that, we've come to the end of today's session. Thank you, Mr. Nyacham. Thank you so much, Mr. Samuel. And thank you, Miss Eunice, for staying with us and also helping us run through today's program. And with that,
Thank
I
you,
want to say
sir.
good night to everyone. Please enjoy the rest of your evening. Sleep well, rest well,
Thank
and
you.
we'll get back to our mentees on the tasks for next week, on the simulation for next week, and maybe any further details will be communicated on your group, on your platform
Please
rather.
let
Thank you
them
very much, and good night, everyone.
let mentees ensure that they read the scenario and make the processes. We want to see the processes involved in the arbitration. let it be the documents, the processes, some of the meetings you need to have, and all of those things. We want to see it in real sense. So please, mentees should go and make research. Go to YouTube, see sessions, as in look at sessions, how these things are done, so that we'll come and have a very interactive and interesting session. So please, let's try and do that. Read the scenario and then begin to put what you need to put together for us to have a wonderful session. Thank you.
Thank you very much, sir. And
Thank
good
you,
night,
sir.
everyone.
Nice,
Good night, sir.